Can a court require a guardian to take part of a beneficiary's estate and hand it off to another beneficiary? To find out, you have to read Matter of Lillian G, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is a recent important case called Matter of Lillian G, published by the Second Department Appellate Division on August 31st of 2022. The citation for this case is 208 AD3D 877. And the issue in this case is whether the Supreme Court has the authority to order a guardian to pay out a prospective beneficiary's portion of the estate following the death of the decedent. And to understand and appreciate what's going on in this case, you have to understand briefly that under MHL Article 81, which is the guardianship statute, a guardian can be appointed for personal needs or property management. And sometimes a guardian is appointed because someone has done something funny with the money of a person who's alleged to be incapacitated. They're stealing the money, or they're converting it, or they're taking it, or they're using it in some way that's inappropriate. And sometimes people file an Article 81 application for the purpose of having a turnover proceeding conducted after a guardian's appointed. A turnover proceeding under MHL 8143 authorizes a guardian. It's a proceeding that takes place after a guardian is appointed, where a guardian can say, you took the money of the incapacitated person while they were incapacitated, and you have to give it back now. I'm going to pursue you on behalf of the incapacitated person and make sure you pay back the estate of the incapacitated person because they need that money, and it was wrongfully taken from them. That's 8143. And the last thing you have to know as background is under MHL 8144, the very next subsection, that describes the proceedings that have to happen after the IP dies, after the incapacitated person dies. And under that section, 8144, it says that within 150 days of the death of the IP, of the incapacitated person, the guardian has to notify everybody that's required to be notified, and has to give the bulk of the estate to the next person on the conveyor belt, basically the public administrator or the personal representative of the estate, basically moving it towards surrogate's court where the estate will be distributed. And the only thing that a guardian is allowed to keep and maintain control of after they do that is the amount of money that they're going to need on hand to pay off any debts, liens, claims, administrative costs related to the guardianship. That's 8144. Okay. And they basically file an application to judicially settle their final account, and people can make objections to it, and the court rules on it and thereby relieves the guardian of personal liability. Okay. So what are the facts here? The facts are that this is a guardianship case about someone named Lillian G, and she had 2 living sons in 2016. Her 2 living sons were Stephen and Gary. And Gary was not a guardian in 2016, but he was sort of handling her money for Lillian. And he was doing some things that may not have been appropriate. He was borrowing money from Lillian's accounts on several occasions for his personal use. He took $100,000 on one occasion, $77,586.26, and $77,591 for a total of $255,177.26. So Stephen, the other son, files an application for a guardianship to be appointed, for a guardian to be appointed. And when it goes to court, it's discussed about all these issues about the money that was converted, that was Lillian's money. And there's a stipulation reached to resolve the guardianship application. The stipulation is that the sons are going to be the sons, Stephen and Gary, will be the personal needs guardians for Lillian, but that a Part 36 guardian will take over as the property management guardian for Lillian. And in addition to that, the stipulation talks about the money that was converted and says that Gary is required to provide documentation and proof substantiating that he has paid back the money that he took from Lillian while she was alleged to be incapacitated. that $255,000. And he doesn't do so. He doesn't do it. So as a result, in March of 2018, the court removes him as co-personal needs guardian. He's gone. And also says to him, I'm warning you, you better do this or else when this guardianship ends, aka when Lillian dies, they say, we're going to be assessing the amount that you haven't substantiated from your 50% status as a beneficiary of the estate. Now, a few months later, in June of 2018, Lillian dies. So Stephen and Gary were appointed then co-executors of the estate. At this point, remember, 8144 says the guardian has to, within 150 days, start doing all these things to move the estate along. So guardian Judy Mock, who's the Part 36 guardian here, files a motion to judicially settle the final account. And Stephen, the brother who is not the one taking money from Lillian, cross moves to have the $255,000 that had never been established and proven as required by Gary to be paid directly to Stephen from the guardianship assets, just as the court had warned it might do. Basically, the court had said, if you don't do this, Gary, I'm going to take the money that would go to you and give it to Stephen. He didn't do it. So the court then gets this motion and grants the application and directs the guardian to pay from the assets of the guardianship account $255,000 directly to Stephen. Gary then appeals, and this is the case we have. Gary appeals and says, you have no authority to do this. And it goes to the holding here, and the holding essentially is Gary's right. They say, here's the situation. The situation is that a guardian is a guardian for a living person, and the guardian's authority to act dies when that living person dies. And in general, the general rule is that all the property in the guardianship account must go to the next person in line, right? Under 8144. The only thing that the guardian's allowed to hold back is things directly related to the guardianship, like things like debts or liens that are directly related to the guardianship itself. Here, the holding says from the Second Department, that's not what we have here. This claim precedes the guardianship. It's a claim that the son stole money from the IP before she had a guardian. It's not related to the guardianship. It precedes it. So it's not allowed to be held back as part of the order settling judicial account. And so the court here exceeded its authority by making the guardian hold back money beyond its authority and hand out money beyond its authority. That's really up to the surrogates court. And that's the holding here of Matter of Lillian G. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.